A New Hampshire last will and testament is an essential estate planning document that can be created quite easily and quickly. Best of all, wills can be drafted without hiring an expensive attorney in most cases, if provided proper guidance. In this video, we'll go over the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in New Hampshire, and how and where to create an official will. First, let's start by discussing wills and their importance. A last will and testament, simply known as a will, is a written document that provides instructions on how to distribute an individual's property after their death. The person to whom the will belongs, known as the testator, can name beneficiaries who will receive all or a portion of their estate. Usually these beneficiaries are spouses, children, and blood relatives, but they can be any person or organization the testator selects. Now, what occurs if no will is left? A person who passes away without a will in New Hampshire essentially loses control of who inherits their property. Instead, state laws determine how the deceased assets are managed. The deceased estate typically transfers to their spouse or any children in these instances through a set formula. Leaving one's property in the hands of the state can cause loved ones to dispute decisions, which can lead to unnecessary arguments and even potential court trials. Therefore, it's highly recommended all adults make a will, especially those who are elderly or suffering fatal conditions. Fortunately, making a straightforward will is often a simple task, and what's best, it can be accomplished without an expensive attorney required. A person of sound mind can draft their will in New Hampshire with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. Finally, let's wrap it up by reviewing the legal requirements in New Hampshire. Wills in New Hampshire must be signed by the testator in the presence of 2 or more competent witnesses. Both witnesses must also sign the document after attesting the testator's signature. Though optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once all parties have signed, the document will be legally binding unless otherwise revoked or revised. Several copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for New Hampshire that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.